Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction. Good evening, folks, and welcome to Divorce Talk Radio. This is attorney Brad Tengler here in the studio with Geoff Carter. Hey, Geoff, how's it going?
I'm doing well. The weather's nice, and I'm excited to be back on another show with you.
Well, today's topic of conversation is removal.
What does that mean?
Removal is a legal term that means obtaining the permission of a court to take your child out of state on a permanent or temporary basis to live. So this arises, obviously, in a lot of situations where someone wants to move to Wisconsin and they currently live in Illinois with their child.
Okay. Now, what's the process of something like that, then? How do you go about doing it?
Well, let me begin with looking at the section of the code in Illinois. It's section 609 of the IMDMA, and it says that a person who has custody of their child may not leave the state of Illinois to live with that child unless a court finds that it is in the best interest of the child for the person to be able to do that, for the parent to be able to do that. And as you can imagine, that creates all kinds of complexities and problems, especially when you live close to state borders.
Right. Now, when you say that, what about, because it can be done also within state, because if you move from Belvedere to Macomb or to wherever, Quad Cities, and you're still within the state.
That's a really good question. There's intrastate moves, I-N-T-E-R, and intrastate moves, I-N-T-R-A. The difference is this. I-N-T-E-R, interstate moves, that requires leave of court. So, for instance, if I live in Chicago and I have custody of my child and want to move to Milwaukee or Kenosha, that is going to be a process where I need to file a petition and obtain the permission of the court to be able to do so. Now, oddly enough, if I want to move down to Cairo, downstate Illinois, or to Marion County in downstate Illinois, which is 5 hours away, 7 hours away, guess what? I don't have to get permission of the court. The section of the code, section 609 of the IMDMA, doesn't address that. So you can move 5-7 hours away and you don't have to have permission of the court. But if you move 20 minutes over the border to, say, Beloit and you live in Rockford, guess what? You got to get permission of the court to do so.
That must be a problem, because not all court cases are where one of the parents is like the worst of the two. It could just be the mother has custody of it. So how does that work with, if the father really doesn't want you to move downstate, because you have to figure travel time and everything, like, some places in Illinois could be, 6 hours, or, more than that, and especially if you move out of state, 8 hours, 10 hours, 12-hour drive, if you drive. Can you pretty much just fight it and stop it then? Or is that kind of...
People fight it and stop it all the time. Particularly, you mentioned moving downstate versus moving just over the border to, say, Wisconsin.
Sure.
There would be one way to address the situation. If someone is attempting to move downstate, you might have a current visitation schedule set in place. Let's say, in this particular case, the dad has custody, and he gets a job downstate, and he's supposed to give the child to the mom every other weekend and one night during the week. Well, guess what? If he moves down to Marion County, he's probably not going to be able to give mom the child one night out of the week, and then mom is going to file a petition for contempt.
Right.
Because he's not following the visitation schedule. But that doesn't mean dad can't move. It just means that he's still got to follow the visitation schedule, and in that particular case, it would be almost impossible to do so. That, however, is different than moving 20 minutes over the border to Beloit, Wisconsin, if you live in Rockford. That is prohibited by the IMDMA under Section 609. You can't do it. You're not allowed to do it.
Okay, what about, I know obviously about rights and everything, but if you have custody through divorce or whatever, and the father or mother is not paying child support, you still have to get permission then?
Oh yeah, child support has nothing to do.
Okay, I was just wondering if say, oh, he owes me 20,000, 600,000, whatever, and he's not paying, but we still have custody rights. I didn't know if that mattered or not. It's kind of like, well, I need to get a better job. He's not paying me the money he should pay me, so why should I
be able to move?
Right. Why should I get permission? Well, I'm just curious.
I mean, obviously, if someone owes $20,000 in back child support, there's something wrong going on.
Right. Well, I'm just trying to get
unless for some reason they didn't know about the order, which was probably their fault anyway. But if someone owes $20,000 in child support, something is wrong. But that doesn't mean that if, say, the mother has custody, that she just can't up and move even 20 minutes over the border out of state with the child, because Section 609 of the code prohibits her from doing so. And if she does, probably a judge is likely to grant a change in custody.
I'm guessing a process like this takes some time then. I mean, if they review all kinds of stuff, I'm sure.
What you said right there, I wish every person that comes to me about this issue would realize initially, because time is an understatement. It is an enormous process if people disagree. And, classic situation. Let's say you've got two great parents. Mm-hmm. One happens to be the primary custodial parent. One happens to be the visiting parent. But both parents are on board, well involved in their children's lives. And, let's say the father has visitation. He has visitation all the time. He never skips. He wants to see his kids. He wants to see his kids more. So you've got two very involved parents. The process for the judge to even hear the petition might take 6 months, 8 months, which when people first are considering this probably don't realize.
And that's just to originally hear it. That's not even to finish it. That's just to start it, basically.
Well, this is how you start it. Let's say mom wants to move to Wisconsin and she lives in Illinois. She's got to file a petition. Say, Judge, under Section 609, I think it's in the best interest of my child that we're able to move to Wisconsin. There could be a number of reasons. Maybe her new husband has a great job in Madison or a great job in Milwaukee, or she's got a great job offer in Milwaukee or Madison. And guess what? Madison and Milwaukee isn't that far away from Chicago if she lives in Chicago. And so she says it's not going to interrupt visitation and parenting time all that much. It is going to financially benefit my child because there's a great job waiting for me up there. But the first thing she has to do is file a petition to get in front of the judge, which, 3 weeks later, after she files that petition, 2 weeks later, she will be in the court in front of the judge.
Okay. And then what's after that then?
And that's when the process begins.
Okay. The fun begins.
In Rockford and Winnebago County, as in many of the counties in Illinois, you have required mediation. So just like a custody battle, just like a disagreement about visitation, with removal too, you've got to go to mediation.
So it's court ordered, you're saying?
Absolutely.
Okay.
And here in Rockford, it is ordered by not ordered by local ordinance, but there's a local ordinance about it.
Sure.
But many other counties have local ordinances about it. And it's a very, very good process to help people deal with conflicts that arise between them about their children, because it gets people talking. But the key thing there is that it's also going to take time, because this is how the mediation process works. You're ordered to go to mediation. Then you come back for a status on the mediation, maybe 2 weeks, 3 weeks, 4 weeks. If it's not successful, you'll probably have to go back to mediation again. In Winnebago County, mediation is required up to 3 times by local ordinance. So you do the math on that. If you come back every 30 days just to get through mediation, it's going to take 90 days.
Yeah, that's a long time.
That doesn't mean that sometimes that process is cut short. Let's say the parties are in mediation and the mother says, this is my perspective. The father says, this is absolutely my perspective. The mediator has the option of sending a report to the court saying, hey, the parties are not going to agree, but there is a flip side to that. and that is you can't go into mediation in bad faith.
Explain that more, though.
Sure.
Yeah, I'm trying to figure out what you mean by that.
Meaning this. You can't go into the mediation process and say, well, I'm not going to take it seriously. I don't even want to talk to you about this.
Okay. Right.
I am completely stuck in my mind about what this is, and I'm going to sit here and I'm not going to talk to you about it. You can talk as much as you want, but I'm just going to basically close my ears, not listen, and not talk and not communicate.
Which makes it 10 times harder for everything to be figured out.
Absolutely. You have to at least
with
talk.
Anything. Yeah.
With anything. So the court requires that you approach mediation in good faith, or let's say someone says, I'm not going to show up to mediation. So they don't call the mediator. If they call the mediator, then they cancel, and they don't have a good reason for canceling, or this keeps happening. That's bad faith as well. You got to go to mediation. You got to talk honestly about the situation. That doesn't mean you set aside your own perspective, but it means that you really try to work through the situation. Obviously, some situations, people are finally going to come to a point where they simply disagree, but you got to take the process seriously.
I mean, I know some people that the whole moving downstate or whatever it's worked. My friend Michelle has done that, and it worked. Her baby's daddy or whatever you want to call him is in Peoria, and they have a workout program where it's like, every month he'll come get her for 2 weeks or whatever, and then switch it off. The only thing is during the school season, she has primary custody, so I understand that she can't. Obviously, you can't have two schools. I don't think you can. Just 2 weeks here, 2 weeks there, but. It seems like they get along real well. During the summer, he'll have her for a whole month, and they'll come back, and then the same thing back and forth. And it seems like they get along pretty well as long as custody's being paid. It seems like they came to an agreement because money was better up here for her, and things were better for him down there with family. So obviously, it's so much easier just to try to work it out and make it best for the kid, because the only person that really is getting hurt is the children or child in the long run, I would think.
Jeff, I think you hit the nail on the head there, and your friend obviously is doing a great job because these situations can work. Both parties have to have really genuine discussions about these things, but it sounds like what she did was take into consideration, hey, my child's dad is not going to be around during the week if I move. And he was probably saying to her, listen, if that's going to happen, I need a lot more time with my child during the summer.
Right. Or winter or anything,
Or winter.
Breaks,
so, maybe 8 weeks during the summer, or maybe holidays, when the child gets a 3-day weekend, which pretty much happens sometimes once a month.
About, yeah.
Or long Christmas breaks or spring breaks, things like that. There's ways to make sure that the visiting parent gets just as much time, if not more time, despite the distance.
And I guess some of the hardest times, I guess, are certain holidays that matter the most. Like Christmas Day, you got to figure out if you're a few states away, what we're going to do. We're going to switch out every other Christmas, or am I going to drive down 10 hours, pick you off for Christmas Eve, and then drop you back off Christmas Day? I mean, I'm sure there's things that you got to try to work out when it comes to things like that.
That's tough.
Yeah.
I mean, if someone
even in town, it is tough.
someone moves to say Milwaukee. We're an hour and a half away from Milwaukee if you live in northern Illinois. So not that big of a deal when it comes to holidays. But let's say someone wants to move to California.
Yeah.
Or let's say someone wants to move to Hawaii.
We're talking about days difference.
Yeah, we're talking about a situation where there's no way the child can be with mom and dad at Christmas on the same Christmas.
Well, and financially, it's especially when you talk about California. For you to drive, it's almost 3 days, so you have to fly, and the ticket's $400 to $600 if it's last minute, and you're not going to fly a 5-6-year-old by itself. So that means somebody's got to go with and come back. So, man, it's a tough situation.
And those financial issues are often issues that need to be addressed in the context of the removal situation, because obviously the custodial parent who wants to remove doesn't want to pay all those expenses. On the flip side, the visiting parent is saying, listen, you are taking my child, very far from me, or you want to do that. Not only is it going to hurt my ability to see the child on a regular basis, say on a weekly basis, but now we have this enormous cost. Who's going to pay for that cost?
Oh, and risk, too. I mean, travel risk, yeah.
And travel risk, sure.
With the way everything's going, if plane crashes and everything else, yeah, you got to be afraid.
Are you afraid of plane crashes?
No, I'm not, but I've been seeing more and more lately, though.
No, I got you.
There was just another one was that in Pakistan just crashed. But.
Well, or even let's say, planes aren't crashing. You've got a 4-year-old child.
Right.
Or a 3-year-old child. What are you going to do? Put that child on the plane all by himself?
That's what I mean. No,
that's not going to happen. So someone's got to get on that plane with the kid and go to California or come back from California. So it's not just the cost of the travel for the child, it's cost for the other parent who needs to be with that child.
I wonder, maybe you know this from working cases like with custody. I'm pretty sure you can one of the parents, can they take that maybe off the child support? Like if you say, well, I'm spending $1,200 twice a year to fly him down or fly her down, is there a way you could maybe take that off of the amount?
Really good question.
Okay.
Technically, can it be, quote unquote, taken off the child support under the statute?
Deducted, right.
Deducted? Not really. Does that happen? Absolutely. If someone is paying their child support and all of a sudden there's this additional transportation expense. Normally parents are expected to share transportation costs. Mm-hmm. Hey, you drive one way, I drive the other. But if someone is moving out of state, that might come up for negotiation, or simply a judge might order that. Obviously it depends on a lot of other things in terms of how judges might approach that, but that's something that is often negotiated. It makes sense for it to be negotiated, especially if you have a travel expense to California, out west somewhere, or even on the East Coast, which is still 12 hours, give or take, from Illinois. Absolutely.
Now, let's say you start this whole process here in Illinois, and then the father moves to Texas or any other state, and then decides, you know what, I want to fight this again. Does that mean that it's going to be handled in Texas, or does it depend on where the child is predominantly at, like where the sole custody's at? If the mother moves, she has custody, and she moves to Wisconsin. All right, you know what? I want to challenge this even more, and I want sole custody. Whatever the case may be, what she might want. Does that mean the file pretty much goes on hold or stops here in Illinois and then moves and starts to open another one there and start?
That is an excellent question.
Crazy question, but
because think about it. So you have dad and mom live in Chicago.
Sure.
They're divorced. They have a child together, and the litigation is in Chicago. Mom has custody, wants to move to California. So they work that out. Mom goes out to California with the child. And then all of a sudden, she wants to file a petition addressing custody or visitation or child support issues in California. So now, dad doesn't have easy access to the court system either.
Oh, more money, more time.
So, one of the items that are often put into orders in removal situations is that Illinois will retain jurisdiction.
Is this where it started at? Is that how that works? Or the origin of it?
That's often put in the order because that way dad has worked out, mom has worked out the whole removal issue, but dad does not want to be what's, I guess, called prejudiced by the possibility of having to litigate the case over another issue, child support or visitation, in the state that's 3,000 miles away. So in orders, often is an order that says Illinois shall retain jurisdiction. And that way it puts really the burden on mom to come back to Illinois to address any of these issues if she has custody and is the one who's moved, or vice versa if dad has custody and is the one who's moved. And it protects the party who is staying in the home state.
What about people that I'm guessing there's? I mean, this is kind of another weird question, but I'm guessing there's some situations, just like myself. I lived with my grandparents, and for whatever reason it was, neither one of my mom and dad didn't take sole custody. Now, but they still got to see me. What happens in that situation where an aunt, I don't know, adoption family or not adoption family, let's just go with family, aunt, grandma, grandpa, whatever, have custody of a kid, but still let the mother and father see? How's that work? Same rules apply with if they move out of state, same thing, where they got to get permission from both. See what I'm saying? Like, I'm guessing there's situations where neither one of the parents are fit for full custody and grandparent or somebody steps in.
Well, you bring up a really key point.
You see what I'm saying?
Permission from the parents. It's not about permission from the parents.
Well, you know what I mean. The court.
It's about permission from the court.
Okay. That's what I meant.
Yeah, permission from the court. Yeah. I would have to look specifically more at the IMDMA and maybe the probate court code, because probate deals with guardianship situations for grandparents or any other family member who might have guardianship of a child. But my guess, I'm not absolutely certain, but my guess is that in that same situation, 609 of the IMDMA would apply, because just because the grandparents have custody or guardianship doesn't mean that they can take the child anywhere they want to.
I'm guessing that happens. I mean, it has to happen sometimes.
Absolutely. I mean, we have other family members having guardianships of children all the time. All the time.
Now, I think I asked you this off air, and I can't remember if you said I could or could not. Now, does this affect also on vacations and trips or no?
On minor vacations and trips, those things can easily be put into a joint parenting agreement.
Okay.
Because everyone wants to do that.
Right.
You know, it's classic.
The summer thing.
Dad is the custodial parent. Mom is the visiting parent. Both mom and dad want to be able to take their kid for 2 weeks in the summer to Disney World. You know, and so what they do is they put that into their joint parenting agreements when they get divorced. They also put in that agreement, you've got to give each other 30-day notice.
So that's on paperwork and everything. That's in file.
Yeah, it's always good to put that stuff in paperwork that gets entered as a court order. But those are usually not that big of a deal.
All right. So what else about the process should we know? You said file the petition. We got mediation. What else is a key part of the process of getting the whole removal?
So after a long and grueling mediation sessions,
yeah, no joke,
where the parties do not agree and fight and simply get to the end of it and say, listen, we've approached this in good faith.
Can I ask you a real quick question while we're on mediation? Who does that then? Just a certain psychiatrist then? Is that they just, how does that work? When you say mediation, you're with a doctor, I'm guessing, or no? Very good question. You're not. Oh,
mediators are not psychiatrists or doctors.
Oh, so that was all rough. Okay.
Well, I mean, it's a good assumption. They're not mediators or doctors. They are in Rockford. They are certified by the county after they've taken some additional continuing legal education classes.
Okay.
They're certified. They don't have to be lawyers. Many of them are. Or many of them are, say, licensed clinical social workers. So I guess that would be along the lines of a counselor or a psychiatrist.
Right.
But they don't have to be doctors.
Yeah, you're talking about 7-8 years. Big difference, yeah.
They have to go through the training. They have to know how the process works. They're on a list in every county, as far as I understand, and then people can pick from that list to use them as mediators.
Okay, I just had to get that question out
there.
And you said, all right, you went through the whole hours and time and all that money of mediation, because I'm guessing you have to pay for that, right?
Yeah, but it's cheap.
Oh, okay. Well,
I mean, relatively speaking, and people always complain about the cost of mediation. It's $50 a session in Rockford, $75 a session, as compared to the next step, which is very expensive.
And which is?
Guardian ad litem.
What is that again? Because we've talked about this before, and it sounds like a huge thing.
It's a very, very fancy word that simply means a lawyer who is appointed by the court to represent the best interest of the child or children.
Okay.
Has to be a lawyer, has to be appointed by the court, and their duty is to tell the court after investigation what they think the best interest of the child is. In this particular case, the court has to make a determination in removal cases what is the best interest of the child. And so it's the guardian ad litem's job to do the research and to make a report to the court what they ultimately think is the best interest of the child.
All right.
Sounds simple, but it's not.
All right. Okay, so you have the female and the male, the husband and wife or whatever, they both have their own lawyers, and then you add another one in it, then you're saying?
Oh, yeah.
So there's a third one.
Yeah.
Okay.
So you can just start
and you have to pay for him too.
Oh yeah, just start counting the money. So you got it. So the ex-wife has paid her attorney or retainer, which at that point has to be used up by that point. Mm-hmm. The husband or the ex-husband has paid his attorney or retainer, and at that point has probably been used up. And then all of a sudden we get another lawyer involved, and that's the guardian ad litem, and they have their own retainer. And those retainers run anywhere from, In Chicago, I'm sure it's much more expensive. Out here, it's $1,500 to $2,000. And all of a sudden, you've got an additional retainer that you've got to come up with to address this issue.
How does that work with the retainer? Then who pays that? Which one? Or is it split up?
Usually, it's split half and half.
Makes sense.
There are exceptions when, let's say, mom makes $100,000 a year and dad makes $20,000 a year.
Possible. Yeah.
Then the judge might balance that out a little bit, but pretty much 50-50. So if it's a $1,500 retainer, mom's got to come up with $750, dad's going to come up with $750. And that's a drop in the bucket. I mean, that just gets you going. That gets the initial research done. There's much, much more money if the case actually goes to hearing and the guardian ad litem has to do more work.
Wow. So the divorce, you have to pay for everything to file for divorce and make sure it's official. Then you have to pay child support, whoever does that. Then you have to pay to do this whole process. Wow, there's a lot of money in this.
If you're in the middle of a divorce, that's right. You're coming up with the money for your attorney. You're coming up with money if you're having to pay child support for the child support. If it's maintenance, you've got that going on. And then you've got to come up with the retainer for the guardian ad litem if you're fighting about custody, in this particular case, removal.
So why can't just two parents get along and just write up some way, or type up an understanding between each other, saying this is how it's going to work, and just like my friend did. Well, obviously it's working because they're doing it. I mean, I don't know. I don't think they're involved in any.
Well, think about having your own kid and your ex wanting to move to California.
Oh, right.
In a situation like that, obviously, everyone wants everyone to come to an agreement about everything. But what your perspective on what is right for the child is different than from what her perspective is for what's right for the child.
Of
Both
course.
parents want to be able to see their child. Mm-hmm. So naturally, you're going to have disagreements at times.
All right.
So guardian ad litem gets appointed, and then they begin doing the research process.
So I guess it's kind of hard because just like myself, when I'm putting in for radio jobs and you have to figure out, all right, I got to find out moving and cost of moving for myself, the moving truck, the rent. I got to find all that stuff up. And then to get a job offer saying, all right, I want you to start in a month from now. And this process was probably going to take, you make it seem like 6 months, maybe a year.
That's one of the biggest anxieties for cases like this. Because,
if we're in a rush. Yeah.
Exactly.
Yeah.
Usually people feel like they're in a rush because if the custodial parent wants to move and they've been offered a new job, what are they going to tell their employer? Hey, I can't move for 6 months. Or actually, it might actually be 8 months or 9 months.
Yeah, close to a year. Right.
And it puts them in a very, very difficult position, but that's what Illinois law is. And the law there's good reason for the law. Mm-hmm. It doesn't make a lot of sense when we're talking about how you can't move to Beloit if you live in Rockford.
Yeah.
But you can move to Marion County downstate. That is where the law doesn't really make sense. But the idea of the law was to keep someone from automatically moving to, say, Florida from Illinois. Or if you live in, if New York or California. In that context, that makes more sense. So
sure.
The law isn't perfect in my mind, but
there
is a logic behind it.
All right. So guardian ad litem, that gets figured out. Then is there another process after that then?
There can be. Guardian ad litem's job is to make a report to the court and tell the court, this is my perspective. I'm not biased. I don't represent the mom or the dad. I simply am trying to represent the best interest of the child. And that doesn't mean that they're representing what the child wants. So let's say the kid's 10 years old. It's not the guardian ad litem's job to represent what the child wants. It's their job to represent what they think is best for the child. Those two different things. So they talk to everyone in the family. They might investigate where the parties are going to or want to move. They might talk to school teachers. They might talk to doctors, to social workers who are involved in the child's life.
Sure.
And then they come in front of the judge and tell the judge, based on my investigation, this is what I think is in the best interest of the child. But that doesn't necessarily stop the process.
No. Ugh.
And the reason being is at that point it's simply them giving their opinion, And then the parties might say, well, listen, the guardian ad litem thinks it's in the best interest of the child for the child to be able to move out of state. However, I know the child's social worker, and the social worker has a different perspective.
Sure.
And this is why. And at that point, the judge sets the case for trial. And people can come and testify, the social worker can come and testify, the guardian ad litem. This is kind of odd. And I think we mentioned this when we were talking about guardian ad litems in a previous podcast, is guardian ad litems not only are attorneys, but they also, when they're functioning as guardian ad litems, can be asked to testify.
Oh, really?
Yeah. So just like anyone else, just like any other witness can be asked to testify, they can be asked to testify, and they're subject to being cross-examined. They're subject to being, that would be for purposes of impeaching them, saying, hey, when you did your investigation, did you talk to the social worker? No. Oh, you didn't, really? Did you know that the social worker, did you have any idea that the social worker had this perspective? No, because I didn't talk to them. And so that undermines their evaluation of what is in the best interest of the child, and then the opposing party puts the social worker on the stand, and the social worker testifies. Obviously that's normal. I mean, normally guardian ad litems are talking to the social worker.
I would hope so, right?
People. But that's one. There are cases where
they don't,
or the guardian ad litem might say, yes, I did talk to the social worker, but you know what? I have a different perspective, and this is why. And then you've got kind of two competing experts. You've got the guardian ad litem who's testifying, you've got the social worker who's testifying.
So the last thing I'm really going to ask you then, what's the, I don't know if you could say percent, or what's the likelihood of a success for one of these removals?
Who knows?
Huh?
There are so many factors that are taken into consideration with the best interest of the child.
I can already tell that, yeah.
That when you begin the case, you have no idea. And that is very difficult for people to hear sometimes, but they're simply often put in these situations. It's usually job-related. Someone needs a job.
Or a better offer, right.
Or a better offer
right.
somewhere.
All the time.
We're not talking $5,000, going from like making, 40 to 45. It might be going from making 40 to 80.
Right. Huge difference.
A huge difference.
Which means more money for child support anyway, I would think. Things get better. That's what the whole thing is. We'll touch on this real quick, but what about when it has to do with the age of the kid? Does the kid have a choice ever come in? Like, obviously a 10-year-old, no. But what about somebody that's 16, 17, and you still have custody? Can they say, you know what, Mom, I know you want me to go with you, but I'm staying here. I have my friends here. I have my job here. I don't care what either one of you guys say. I'm staying with Dad. Can you do that?
Really good question. The answer to that is yes and no. Can children ever make the decision about who has their custody? No.
See, why did I think that? I thought
everyone thinks that. Okay. I've had so many people come to me and say, "Hey, when does the kid get to choose?" And never. That's just not the way it works. Is it a factor? Is the child's opinion a factor?
Oh, I hope it matters. Yeah.
Is that factor weighed more heavily depending on the age of the child? Yes. Is it weighed more heavily depending on the reasons that the child has? If the reason that child doesn't want to move out of state with mom is because mom makes child do homework every night and has a curfew, that's not going to cut it when it comes to the judge making an evaluation of best interest of the child. Mm-hmm. But if the child has a good reason, and in a situation with older teenagers, 16, 17-year-old teenagers, there's probably going to be a lot of weight that's placed on their perspective because they're older.
Right.
They're almost young adults. And obviously they have bad reasons for what they want sometimes, but sometimes they don't.
Well, there you go. I learned a lot. This is a lot more than I thought I would learn. It's crazy how this thing can unravel.
Well, I just, I suggest when people are beginning the process of making a determination about whether or not they want to move out of state with their child and they have custody, is they got to be prepared for the long haul. They've got to be willing to communicate with their ex and to have genuine conversations and to take into account their feelings and perspectives so they can try to work something out. But they've got to be prepared for a long process and understand that the outcome may and probably is uncertain. It's unfortunate that they're placed in difficult situations where jobs force us sometimes in this day and age to move, 1,000 miles away or thousands of miles away from from our family. It's a reality of the work environment today.
Absolutely.
But it doesn't take away from the fact that a removal case sometimes is very, very lengthy and often uncertain.
Well, there you go. Well, thank you, Brad, for this. It was a very informative episode of Divorce Talk Radio.
Absolutely.
Now, how about if somebody's listening or whatever and want to go through it or, do a process of removal? How do they contact your law firm?
We're at 515 North Court Street in Rockford, and we can be reached at 815-997-5200.
And you also have a website, correct?
Yep, tenglerlaw.com.
Oh, real simple, real cool. Another good episode of Divorce Talk Radio
Thanks,
on RockfordCollegeRadio.com. You're welcome. Thank you. You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tengler, please visit TenglerLaw.com.